Good morning, everybody. Welcome to the first in-house in focus session of 2025. Today, we are conducting our sort of annual contract review quiz that has become part of a tradition here. We're looking at some of the key sort of developments in 2024, some of the interesting case law which has come out about contractual law topics. Today, I'm joined by my colleagues Avneet and Michael. So for those who've not met me before, I'm a partner in the commercial disputes practice here at Mills & Reeve, based in our London office, and I'll allow Avneet and Michael to introduce themselves.
Hi, good morning, everybody. My name is Avneet Baryan. I'm a senior associate in the London disputes team and do all things commercial disputes, basically.
Hi, good morning, everyone. My name is Michael Vivona. I'm a trainee in the disputes team in London.
Fantastic. Just before we begin, just a little bit of housekeeping. The session today is recorded. As in previous years, we've run this as a quiz where we give fictitious scenarios, and then there's a pop-up screen just with suggested answers. Please do feel free to answer the poll. It makes this session a bit more interactive and fun. But rest assured that the answers are anonymous, so those who are attending won't see who answered what. Also, there is a Q&A function at the bottom of the screen. We'll try and address any answers at the end. Again, they are anonymous to whoever is attending. So in respect of the first question, I'll let my colleague Avneet take that.
Right. So it's just come up on the screen. I'm going to read it out quickly or briefly. I appreciate it's fairly detailed as well. So it's City Pharmaceuticals Limited had a patent for a new weight loss drug and partnered with Greendale Community College to explore its use in treating obese patients in the UK. So after promising pilot study results, they moved over to a preclinical study, which was funded by City, and they entered into a research agreement. Now, that agreement provided that Greendale would not be liable for any loss of profits, business, contracts, opportunity, goodwill, and other losses because of any representation, unless fraudulent, or any warranty, express or implied, or other term, or any duty at common law. Quite wordy. The limitation of liability clause limited the liability of the parties, however so arising, in respect of any breach. And there was an exception in the case of fraudulent misrepresentation. That limitation was up to 2 million. So an issue arose where Greendale published inaccurate sample data, leading to the end of the pilot study. And City alleged dishonesty, and they claimed for the costs of repeating the project again at 2.3 million, and also claimed for 100 million for loss of value of its patent due to the delay. So the question is, what would the High Court decide regarding the liability cap and City's claims? So is it option A, liability cap of 2 million applied, and City's argument about researchers' dishonesty would be unsuccessful? Is it B, liability cap did not apply, and City was awarded the full 2.3 million claimed? Or is it C, a liability cap applied and City was awarded over 100 million loss of patent value that was claimed?
Clear favourite.
A lot of results coming in, which is great to see. So I'll end the poll there and share the results. The answer is A, that there was a liability cap of 2 million. So just kind of working through the actual case that this relates to, that's the case of Innovate Pharmaceuticals Limited and the University of Portsmouth. So the fact pattern mirrors this one, just a slight change in values and names. So Innovate was a small pharmaceutical company. They developed the drug and hoped to license it to pharmaceutical companies. Now, the University of Portsmouth specialised in research into brain cancer, and in 2016, the parties reached a research agreement where the University of Portsmouth agreed to undertake research into the efficacy of the drug and testing with a view to innovate later marketing it. Now, the person in charge of the research, Dr. Hill, published a paper about the drug in a scientific journal, and that contained numerous mistakes which had to be retracted. A subsequent disciplinary committee found that Dr. Hill was guilty of research misconduct, but reached no conclusion on dishonesty. Now, Innovate commenced these proceedings, initially claiming misrep, but then alleging breach of contract. Now, the question that was to be decided was whether Dr. Hill had been dishonest in writing the paper, because that was critical to the case, because the exclusion clause in the contract provided that the University of Portsmouth would not be liable for any loss of profits, business, contracts, opportunity, goodwill, and other losses because of any kind of representation, unless it was fraudulent. Now, the limitation liability clause also limited the liability for the parties for any breach, and again, providing an exception in the case of fraudulent misrep to 1 million. So the High Court found that Dr. Hill had been extremely careless rather than dishonest, which meant it didn't meet that kind of threshold. So the actual cap applied. And what the High Court did decide, they said, look, this 1.3 million that you're claiming is what we're assessing, and we're going to cap that at 1 million. And then the further claim for the loss of the patent, they didn't look into assessing that because the cap was what it was and applied in those circumstances. The court also dealt with UCTA to look at reasonableness as well of the actual term. So various factors were considered, such as there being no inequality of bargaining power between the parties, and that the terms had actually been actively negotiated between Innovate and the University of Portsmouth, and also the fact that the sums that were paid to the University of Portsmouth were very low. So, in short, what does this case tell us? It really highlights the importance of careful drafting, particularly in life sciences contracts and research agreements, ultimately to allocate risk in a way that works, if you actually think it through, trying to limit liability, and then reduce the risk of a dispute later on. Care should also be taken for any exclusions. So are you making an exclusion for fraud, dishonesty? And in the context of research, what is a good way forward is actually to make sure that there's a greater degree of involvement and oversight by the research sponsor, which actually might have helped identify problems sooner. Now, we'd normally expect to see structured interaction throughout the research project. That's always preferable to identify and address problems as they arise, rather than participate in a court battle later on, as we saw here. We have also got, just a flag, we have an article on this case on our website, effectively drafting for a disaster. That's what it's called, a research project gone wrong. I will now hand over to Mark for the next question.
Perfect. Thanks, Avneet. Yeah, in the follow-up to this, we'll send a link to that article and a couple of other articles that relate to the cases that we're talking about. Avneet touched on a good point there about effectively just oversight of commercial agreements. And it's one of the things that we touched on in an in-house in focus session about how to avoid contractual disputes. That one of the things we recommended, and we appreciate that in-house legal teams are extremely busy, but whether there is sort of a routine review of key commercial agreements, just where there's a check-in point, just to see what is happening and whether there's actually any issues where, a commercial agreement or a project is starting to come off the rails a little bit. The second question we have is on force majeure, which obviously was very topical during COVID. We haven't seen the sort of the unleashing of the floodgates of force majeure cases entering the courts post-COVID, but it is still arising. My commercial colleagues ran a session in December just around commercial law updates from 2024, just before Christmas, where they touched on this case. And for those who joined the quiz in January 2023, we touched on the Court of Appeal decision of RTI and MUR shipping. And here we're going to pick up the Supreme Court's decision as that saga has continued. So the factual scenario that we have here is that Coyote and Acme enter into an agreement where Acme is required to pay Coyote in sterling. There's then a sanctions package issued by the UK government, which catches Acme's Mexican parent, which means that it can't pay in sterling anymore. But Acme says, look, we can't pay in sterling, but we can pay you in an alternative currency that's not caught by sanctions, so here euros, and we'll just pay any additional conversion costs. Coyote refuses and ceases supply, and then gets sued for breach of contract. Coyote argues that actually there's a force majeure provision which has been triggered because of the sanctions package, and it's not possible to overcome that by reasonable endeavours. So just following the RTI decision in the Supreme Court, what would likely be the legal position in that scenario? Is it the poll is pulled up, Acme can make the payment in euros, so the force majeure provision is not engaged. The force majeure provision has been triggered as it's not possible for Coyote to comply, or is it that the parties are required to vary the contract in order to avoid the breach of sanctions? So the correct answer here, which 47% of people got, is B. And I sympathise with why there's quite close answers between each of them, because this case has effectively gone through 4 iterations now, where effectively a different decision has been decided each time. So first it went to arbitration, where the arbitrators said that effectively that the recipient party should have accepted payment in euros. At the first instance, the High Court said, no, that's not correct. The reasonable endeavours obligation under the force majeure provision doesn't require the party who's invoked it to effectively accept non-contractual performance in order to overcome that force majeure event. As I said 2 years ago when we picked this up at the Court of Appeal level, that High Court decision was overturned by the Court of Appeal and said that that effectively the payment in euros should have been accepted. And then we pick it up in the Supreme Court, which hopefully overturns the Court of Appeal decision and says that actually the party did not have to accept party in an alternative currency in order to overcome a force majeure provision which required it to use reasonable endeavours to overcome it. And so standing back, in that case, it was RTI suing MUR for breach for not providing shipping services because MUR was refusing to accept payment in an alternative currency. And it was MUR that said, look, a force majeure event has occurred and we can't supply the services. What the Supreme Court said when it was saying that actually that MUR did not have to accept payment in an alternative currency was that fundamentally, as a matter of English contract law, the starting point is that the English courts are there to enforce the terms that the parties have chosen. It's that fundamental purpose which provides the certainty in commercial contracts in English law. And so what it said that when you're looking at that in the context of a force majeure event, even if there is an express obligation that you've got to use reasonable endeavours to overcome a force majeure event, you're not required to accept alternative performance that's not provided for in the contract in order to overcome it. So, if you're looking at force majeure events and there's something there where you're being asked to accept alternative performance to overcome the force majeure event, or you want to insist on the other side accepting alternative performance to overcome the force majeure event, what this Supreme Court decision says is that effectively you're going to need prior written consent beforehand. I think what's quite interesting about this case is that it's focused on MUR being sued, for refusing to perform services. What would have been interesting is if in this case it was MUR that was suing RTI for non-payment. And the reason I say that is because parties have got an obligation to mitigate their losses when they're suing for damages. And here, obviously, MUR could have accepted payment in euros, even though it wasn't the currency that was provided for under the contract. It could have accepted payment in euros. And I think in that scenario, the court would have said, well, yes, MUR, you should have accepted payment in euros in order to mitigate your losses. But obviously that didn't happen in this case. I think if we move on to the next question, which I think, Avneet, you're taking the material adverse change clauses.
Yep, that's right. Thanks very much, Mark. So here you have Green Metals. They signed a share and purchase agreement to buy 2 mines in Moria from Oakenshield in a deal which was valued over 1 billion, and the deal was expected to complete within a couple of months. Before completion, a geotechnical event occurred at one of the mines where a portion of rock was displaced, and Green Metals relied on this event to withdraw from the deal. It claimed that it triggered a material adverse effect clause in the SBAs, and Oakenshield claimed Green Metals wrongfully terminated the agreement, arguing that this event was not an MAE and actually alleged that Green Metals engaged in willful misconduct. So the question is, what did the judge consider to be a material adverse effect in this context? Can we get the poll up on the screen, please? Option A is any reduction in the equity value of the target will be considered material. Is it B, only a reduction exceeding 25% in the equity value of the target would be considered material? Or is it C, a 20% reduction in the equity value of the target would be material, a 15% reduction might well be material, and a 10% reduction would be too low to be material? And the answer is C, and 63% of the audience have got that right. So this scenario mirrors the facts in BM Brazil and Sibanye Stillwater, which is a High Court case from last year. Effectively, Sibanye signed share purchase agreements for these 2 mines, and in the period between signing and completion, this geotechnical event happened, much like the scenario that we said. And ultimately, Sibanye relied on that event to withdraw from the deal. And what it said is it had triggered this material adverse effect clause in the SBAs. Now, if we just look at what the wording of a clause like that includes, and it means any change, event, or effect that individually or in the aggregate is or would reasonably be expected to be material and adverse to the business, financial condition, result of operations, the properties, assets, liabilities, or operations of the group companies taken as a whole. Now, the sellers started proceedings claiming that Sibanye had wrongfully terminated because they said that this event wasn't an MAE event. They also made this willful misconduct point, and ultimately, Mr. Justice Butcher in the Commercial Court found that the geotechnical event was insufficiently material to constitute an MAE. So he agreed with them. And so Sibanye's purported termination was effectively repudiatory breach of the SBAs, and the sellers were entitled to damages. Now, what Mr. Justice Butcher also said is that the actual termination did not amount to willful misconduct, which was interesting. Sibanye had believed that there had been an MAE, but while this belief had turned out to be wrong, it was based on kind of a flawed technical analysis undertaken at the time that Sibanye made its decision. And so actually, the decision turned in part on the specific language in the clause, but looked at it in the context of the SBA as a whole. Now, what the judgment provides is helpful guidance on how clauses like this should be construed, in particular what material means. And actually, in the judge's view, a material effect must be significant or substantial and would not include everything that was more than de minimis. And what the court did is they distinguished between the event itself and any kind of pre-existing issues revealed by the event. And it was only the direct impact of the event that should be considered when determining if such an event had occurred. So Mr. Justice Butcher also said, look, there's no bright line test here. And actually, in this case, there was a 20% reduction in the equity value of the target being material. A 15% reduction might well be material, and a 10% reduction would be too low. So it was a bit of a, oh, well, it could be this, it could be that, could be that. But, you know, what he also did say, look, each case inevitably turns on its own facts and the drafting of the actual clause in question. There was another recent case that was referred to in Finsbury Food against Axis Corporate Capital, which was a case in 2023. And in that case, it was found that a 10% reduction in total group sales was sufficient to qualify as a material adverse change, which is interesting. So ultimately, turns on its facts, look at the clause, and ultimately, really, the burden is on the party who invokes the clause to be able to justify why they've made a decision. Okay, so I'm going to move on to the next question and hand over to Michael.
Thanks, Avneet. So the next question is on notice clauses, and there's one for fans of classic Simpsons episodes as well. So in 2020, Burns Limited sold its shares in Springfield Nuclear Power Plant Limited to Hans and Fritz GmbH. The share purchase agreement included warranties and option agreement for an easement over adjacent land would be assigned to Springfield before completion. After completion, it was discovered that Springfield did not have the benefit of the option agreement. Hans issued a formal notice of its claim on the last day of the extended time limit, seeking damages for breach of warranty. The question is, what did the Court of Appeal emphasize regarding notice of claim provisions? And the options are A, notice requirements should be interpreted based on their language and commercial purpose, avoiding unnecessary technicalities. B, notice requirements must strictly comply with technical details regardless of their commercial purpose. Or C, notice requirements should be ignored if the claim is significant. So the correct answer is option A, which 45% of you got right. So notice requirements should be interpreted based on their language and commercial purpose, avoiding unnecessary technicalities. And this issue was considered by the Court of Appeal in Drax Smart Generation Holdco Limited versus Scottish Power Retail Holdings Limited. So to give you a bit of background, in 2018, Scottish Power sold its shares in a company to Drax. One of the company's assets was a site in Kent intended for a new gas power station. The SPA warranted that the benefit of the option agreement for an easement of adjacent land to enable cables to be laid would be assigned to the company before completion. After completion of the SPA, it was discovered that the company did not have the benefit of the option agreement. Correspondence followed, and the parties extended the time limit for notifying claims under the SPA. On the last day of the extended time limit in June 2021, Drax issued a formal notice of its claim, seeking damages for breach of warranty under the indemnity. It set out the factual situation in detail, but referred to losses suffered by the company rather than by Drax itself. It described the losses as yet to crystallize and set out calculations of potential losses being the cost of acquiring a suitable easement by negotiation or compulsory purchase. Scottish Power did not accept the liability, so Drax issued a claim form, pleaded in accordance with notice of claim. Scottish Power applied for summary judgment, arguing the claim had no real prospect of success because the nature of the claim and the amount claimed had not been sufficiently notified for the purpose of the notice of claim clause in the SPA. Drax sought permission to amend its particulars of claim, and the amendment sought for a reduction in the value of shares meant that the claim was different to that set out in Drax's notice. The High Court held that given the change was not stated in the notice of claim, there was no real prospect of success and gave summary judgment against Drax on the warranty claim that allowed the indemnity claim to proceed. Drax then appealed, and the Court of Appeal disagreed with the High Court's approach and gave permission to Drax to amend its particulars of claim. The court emphasized a more commercial approach to interpreting notice of claim provisions, focusing on their commercial purpose rather than the technical compliance. The court provided guidance that notice requirements should be interpreted based on their language and commercial purpose, avoiding unnecessary technicalities. To impose such a requirement serve no commercial purpose and merely introduce a trap to defeat what might be a valid claim. Further, looking at the wording of the clause, there was nothing in the language of the clause or its commercial purpose which required Drax to spell out that the damages claimed would be based on the difference in value of the shares in the company. So this decision is beneficial for buyers, suggesting the courts will take a pragmatic approach to notice of claim provisions, focusing on the substance over technical compliance. I'll now hand over to Mark, who's going to take you through the next question. Thank you.
Perfect. Thanks, Michael. We're going to touch on cessation of LIBOR now. We touched on the FCA's announcement in the quiz a couple of years ago, where it's said that it wasn't going to compel banks to provide quotations for LIBOR anymore. And there's been a recent decision in Standard Chartered and Guarantee Nominees, which has touched on this issue. So effectively, the scenario that we've got here is that a bank issues a loan to a borrower in 2010, which provides an interest rate of 3% above 3-month USD LIBOR to be paid on quarter days. And the principal repayment date is set for 2029. After the FCA announcement, the publishing of what we call synthetic USD LIBOR rates ceased to be published in September 2024. And so the borrower seeks advice as to what the consequences of that is. So the options that we have there is that the rate that will be used to calculate interest will be the last USD LIBOR rate that was published in September 2024. The courts will step in to imply a comparable interest rate to the 3-month USD LIBOR. The facility agreement is to be treated as frustrated because the parties can't calculate the interest that is due anymore because USD LIBOR is no longer being published, or the borrower is treated as being in default because the bank can't calculate 3-month USD LIBOR. So we've got some conflicting sort of answers here. So we've got quite close there between A, B, and C. Just given the factual scenario here and the case of Standard Chartered, the correct answer here is B. So I think, as I said, the FCA announced in 2017 that it wasn't going to compel banks to quote for LIBOR anymore at the end of 2021. What's happened in the interim period, though, is that ICE, so the Intercontinental Exchange, has continued to publish LIBOR rates for key currency pairs. For example, USD LIBOR for certain periods has continued to be published, and that's what we call the synthetic LIBOR rates. But as of September 2024, they have been ceased to be quoted. And so the reason for this sort of period of having the synthetic rates was effectively to allow parties to try and amend their agreements in the meantime, or in respect of new finance agreements, to allow alternative rates to be used. And what we've tended to see in the market is that for US dollar denominated reference rates, what we call the OSFR, or the Secured Overnight Financing Rate, has been adopted. For sterling, it's been something that we call SONIA, which is called the Sterling Overnight Index Average. And what happens with those is that effectively there's a credit default spread that's applied to those, which comes from ISDA. So it's all become quite sort of complicated, but they have effectively become the market standards. What we haven't actually seen a flood of cases considering the cessation of LIBOR. And principally the reason for that is where in the context of facility agreements, there tends to be a provision which is bank favoured, which allows that where something materially impacts the facility agreement, effectively the bank can step in to amend the agreement to make sure that there is a mechanism there in order to allow the facility agreement to continue. And so that has often been adopted to allow for the amendment to an alternative rate. But in the case here of Standard Chartered and Guarantee Nominees, what was faced there was that there were in 2006, Standard Chartered issued preference shares where there was an interest rate in terms of the dividend that was to be paid, which was linked to 3-month USD LIBOR. And so what happened was that effectively when we got to with the end of September 2024 coming up, Standard Chartered had sought agreement from the preference shareholders to amend how interest was to be calculated. And certain of the preference shareholders said no, and said that actually the impact of it is that the preference shares need to be redeemed. And so what Standard Chartered did was that they sought a declaration from the court about what should happen in this scenario. So Standard Chartered argued that effectively a term needed to be implied to use an alternative rate to LIBOR, while certain of the preference shareholders maintained that the shares should be redeemed. And so the court looked at this and said, look, it's obvious that a term needs to be implied here in order to give the contract business efficacy. So I think we all know that the definitive test now for implying terms into a contract is M&S and BNP Paribas. Apologies if I'm stating the obvious here, but the test for that is that the courts will step in to imply a term if it is fundamentally necessary to give business efficacy to the contract, meaning that effectively that without it, the contract lacks commercial or practical coherence. And so it's so obvious that it goes without saying that that term needs to be implied. When looking to imply that term, though, the court needs to be satisfied that the implied term is capable of clear expression. It doesn't contradict any other express term of the contract, and it's reasonable and equitable in the circumstances to imply the term. And where you've got a long-term contract, such as what you had here with Standard Chartered and Guarantee nominees, on the basis that effectively the preference shares were to last for an indefinite period, what the court said was that effectively that the courts will apply even greater flexibility in those scenarios, because it accepts that it's just impossible for contract drafters to try and envisage every scenario when they enter into a contract and they're being prepared. So taking that as the starting point of where the court came to, it said that, okay, it's obvious here that a term needs to be implied. And it then looked at, well, what term do we imply? And so there was expert evidence before the court effectively saying what the industry and what the market has done since LIBOR has stopped being published. And in respect of US dollar denominated debt, the court was satisfied that effectively the OSFR with a credit spread adjustment has become the market standard. And interestingly, there was the expert evidence was that since 2023, that 78% of US dollar debt issuances has been issued by reference to OSFR. But when you look back at 2006, at that time, 78% of US dollar denominated debt was issued by reference to LIBOR. So in that scenario, it said, well, obviously the market standard is now OSFR for US dollar denominated debt. So we're going to imply a term that it's linked by reference to that. In terms of sort of a takeaway of the case, the court did say that, look, when this scenario about LIBOR happens, you're going to have to look at every case on a case-by-case basis. And whilst it was overture, though, the court did stress that effectively the parties are going to have to act sensibly to try and imply a term. And I think really where the court was hinting there was that, look, you're going to have to look at what the market practice is now and look to try and agree to amend the agreement to refer to what is effectively the market standard. The courts aren't going to try and step in to say that because you can't calculate LIBOR anymore, that a facility agreement should be treated as frustrated. So again, it's not come up that often in practice, but if any of you are facing issues around the cessation of LIBOR, then obviously do get in touch with either your regular Mills and Reed contact or with me, and we can help you try and address that issue. So I think the next question Avneet's going to touch on is around mistake.
Thanks very much, Mark. Right, so next scenario, we've got an insured operator of a restaurant, Le Petit Bistro. They held a premises insurance policy with Umbrella Limited, and the pandemic hit. And Le Petit Bistro sought to claim for an indemnity under the policy for business interruption. Now, the clause in that policy contained an extension for business interruption, and what it required was that it needs to be caused by damage arising from a notable disease manifested by any person while in the premises or within a 25-mile radius. Strange, slightly. Now, damage was defined as physical loss, physical damage, and physical destruction. Now, Umbrella denied liability, stating the cover only responded to physical damage. And what Le Petit Bistro said is that this makes the policy illusory, as it meant that there was cover for perils such as infectious or contagious disease within 25 miles of the premises, but only if they cause physical damage, loss, or destruction. Le Petit Bistro argued that the clause was therefore an absurdity and requested that the court rewrite the policy so that the clause covered non-damage rather than damage cover. So the question is, what conditions did the court affirm must be met for an error to be corrected by construction? Can we get the poll up, please? Thank you. So option A, the policy must be deemed illusory and the court must find the wording absurd. There must be a clear mistake on the face of the instrument and it must be clear what correction ought to be made to cure the mistake. Or is it C, the claimant must prove that the damage definition includes non-physical losses? So the answer is B, that there must be a clear mistake on the face of the instrument and it must be clear what correction ought to be made to cure the mistake. And 68% of the audience got that right. So this particular scenario mirrors that in Bellini against Brit UW Limited. It's a Court of Appeal case, and it's Master of the Rolls, Sir Geoffrey Voss, that gave the leading judgment in that. The facts pretty much mirror what it is. And ultimately, Bellini were seeking to claim an indemnity for business interruption caused by COVID. A really difficult time to kind of see where an existing insurance policy might help in that circumstance. And this is a really good example of how it actually played out. So in the case, Bellini, the defendant Brit denied liability on the basis that it actually only covered damage arising from a notifiable disease. And actually the definition was that there needed to be some sort of physical loss. Now the claimant's argument was that if this was the limit of the cover, then it was illusory because a disease would never cause such damage, and as a result the policy was absurd and actually should be rewritten to provide specifically non-damage cover. Now the Court of Appeal rejected the appeal by the claimant, saying that nothing had gone wrong with the wording. The cover provided was the cover stated and that there was no error to correct. Ultimately, this case is interesting because from one point of view, it gives you a good discussion of how an error can be corrected by construction. And it actually confirms the conditions that were set out in East Panteel by Lord Justice Brightman, and then which was also affirmed by Lord Hoffman in Chartbrook and Persimmon Homes back in 2009. So looking at the conditions, the first is that there has to be a clear mistake on the face of the instrument. And the second condition is that it must be clear what correction ought to be made to cure the mistake. And if those conditions are satisfied, then the correction is made as a matter of construction. Now, some interesting points in this is Sir Geoffrey Voss, he actually looked at other applicable authorities in reaching his decision. He refers to a couple of cases, so one in particular, the Financial Conduct Authority against Arch Insurance. where there's an interesting quote. So it says the core principle is that an insurance policy, like any other contract, must be interpreted objectively by asking what a reasonable person with all the background knowledge would reasonably have been available, which would reasonably have been available to the parties when they entered into the contract, would have understood the language of the contract to mean. Again, quite wordy. So what they're looking at is that evidence about what the parties subjectively intended or understood the contract to mean is not relevant to the court's task. And so ultimately, the policy in this case had to be interpreted as at the 20th of October 2019, when it was incepted, when COVID was pretty, unheard of back then. And so ultimately what they said is, look, you can't interpret this clause through the telescope of COVID. And this, in effect, a retrospective view of what might be the situation. And that's quite an interesting quote there, particularly in this context. So some takeaways, non-damage endorsements commonly supplement predominantly damage-based cover afforded by business interruption insurance policies. However, this case demonstrates that care has to be taken to ensure that the policy wording reflects the intention for the endorsement to be triggered without the need for actual damage. Or the policyholder might find itself without the cover the endorsement appears to provide. I think this also comes into the point of, you have different insurance policies with different prices and levels of cover, and it's just taking that time to see, what is it that matters for your organisation. So moving on to I think this is the last and final question on dispute resolution clauses. I'll hand over to Mark.
Perfect. Thanks, Avneet. Just conscious of time, I'll quickly canter through this. I should add that at the end of February, we're going to conduct another in-house in focus session on dispute resolution clauses, where we will touch on the issue that comes out of this question. But in effect, forward on to later in the year, it gets to September 2025, and you enter into an agreement with a French company. The jurisdiction clause that you agree is the non-exclusive jurisdiction of the English courts. And then you're in a situation where you need to sue the French company for breach of contract, and you're looking at effectively how is the judgment going to be enforced against that French company? What is the most efficient way to provide for enforcement? And so if we pull up the poll, the options that we've got are the Brussels recast regime. We've got the Hague Convention 2005. We've got the Hague Convention 2019. And then the final option we've got is that effectively you'll need to go through the local law procedure in France. Okay, we've got sort of conflicting decisions here. So the correct situation in this scenario is what we call the Hague 2019 Convention, which has the catchy title of the 2019 Hague Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters, which thankfully will come into force in the UK from the 1st of July 2025. And we'll talk more about that in the session at the end of February. But just for everybody's benefit, the position that we were in before Brexit was that the UK was a party to what we call the Brussels recast regime, which was effectively provided a mechanism for the reciprocal enforcement of judgments from the UK into EU member states and vice versa. And post-Brexit, we fell out of that regime. We joined something called the Hague Convention 2005 to try and remedy some of those issues. But Hague 2005 only applies for mutual recognition of judgments where there is an exclusive jurisdiction clause provided for. And so there was always this debate about, well, if you've got a non-exclusive jurisdiction clause or you've got an asymmetric jurisdiction clause, what do you do? And you effectively in that scenario have to go through the local law in France and jump through some of the local law issues that local law hoops in order to try and enforce that. thankfully, the EU ratified the Hague 2019 Convention a couple of years ago with Ukraine. The UK has now ratified it, and it will come into force as of the 1st of July 2025, so this year. And that addresses most of the issues which have been caused by the UK falling out of the Brussels recast regime. We're effectively back in the pre-Brussels recast regime, especially in the context of commercial agreements because of that. And so a lot of the headaches which have been caused by Brexit about enforcement into Europe and vice versa should now hopefully fall away. So conscious of time, just looking at some of the questions which have been asked. In fact, the most recent one here is actually just about sort of asymmetric clauses and what was the issue in under the 2005 Hague Convention. So for those of you who don't know what asymmetric clauses are, it's effectively where parties have agreed usually the exclusive jurisdiction of one court, but one of the parties has the option to actually go in another court in another jurisdiction. So they're common in facility agreements. So usually they agree that the English courts will have exclusive jurisdiction, which means the borrower has to sue in England, but it usually the bank has the option to pursue proceedings in another jurisdiction. So if the borrower's got assets in another jurisdiction, it means that the lender can go and effectively enforce against those assets straight away in another jurisdiction. There's an issue under the 2005 Hague Convention because it only applies to exclusive jurisdiction agreements, whether actually asymmetric clauses would fall within the ambit of the 2005 Convention. So there's conflicting decisions in the UK versus in Europe as to how you treat that question. And so under the 2019 Convention, that issue should fall away, given that the 2019 Hague Convention expressly covers non-exclusive jurisdiction clauses as well. So again, just slightly conscious of time. I think what I'll do in respect to the other questions is we'll follow up directly with those who've asked the questions by email. There should be a pop-up coming up just with just requesting some feedback. Again, we're in the process of devising our itinerary for later in 2025 for the In-House in Focus series. If you've got any topics that you would like us to address during one of our In-House in Focus sessions, then please do provide that in the feedback. It's great to hear what sort of issues that you're facing on a day-to-day basis. The next In-House in Focus session will be on the 29th of January. Where we'll touch on the Digital Markets Competition and Consumer Act. And so that comes into force in April 2025. So my colleagues, Alex, Kate, Katrina and Nicola are going to look at how that impacts your business and what it means for you and what you need to be doing before that comes into force in April 2025. Again, I think I'd just like to thank Michael, Avneet and Kate for assisting today, and thank you to you all for joining. I hope you have a great day, and hopefully I've saved you a couple of minutes and allow you to get back with your working days. Thank you very much and Happy New Year.